So, ladies and gentlemen, welcome to the Geneva Center for Security Policy, and welcome to this Security in Law, a reality check. The Public Event Series Security in Law, a reality check, examines the role of international law in security affairs. And that's what we're doing tonight, this evening. We're going to explore the simple but hard question, do the Geneva Conventions matter? And in 1949, exactly 70 years ago, the four Geneva Conventions rose out of the ashes of World War II. Since then, the Geneva Conventions have regulated practically all wars between states. Their common Article 3 has provided fundamental rules for non-international armed conflicts. Additionally, the Geneva Conventions have set the ground for their three additional protocols, customary international law, and a large jurisprudence related to the treatment and protection of the wounded, shipwrecked, sick, prisoners of war, and civilians. Nowadays, considerable efforts around the globe are devoted to disseminate, train, and strengthen compliance with the Geneva Conventions. As a result, the Geneva Conventions have become more than just international treaties. They have become the symbol par excellence of humanity in warfare. Yet, numerous are modern conflicts in which the Geneva Conventions are not respected. Atrocities are being committed, rights of combatants and civilians disregarded. Moreover, new technologies with uncertain effects on human dignity are emerging. So this raises pressing questions. Do the Geneva Conventions actually matter? Are they really capable of regulating behavior in war? If not, 70 years after their adoption, are the Geneva Conventions ready for retirement? Or, quite the contrary, is their legacy only at its very start? For debating these important and timely questions, we're honored and privileged to have Professor Matthew Evangelista, JeanMarie Han, and Colonel Jelena here with us today. Unfortunately, Jelena Pejic is sick and can't be here with us, but we hope that she's going to recover quickly. And special thanks to Mr. Hankerts for replacing her on such a short notice. If I may quickly introduce our distinguished panelists. Professor Matthew Evangelista is President, White Professor of History and Political Science at the Department of Government of Cornell University in the United States. He teaches courses in international relations and comparative politics. He has widely published and currently researches on the relationship between gender, nationalism, and war, as well as ethical and legal issues in international affairs, transnational relations, and separative movements. Most importantly for today's discussion, Professor Matthew Evangelista has co-edited the new book, Do the Geneva Conventions Matter? A great analysis of how the Geneva Conventions work in times of war. As a second speaker, we have Mr. JeanMarie Han. Mr. JeanMarie Han is the head of unit in charge of the update of the ICRC commentaries of the Geneva Conventions and their additional protocols. Since the original commentaries were published in the 50s and 80s, the conventions and protocols have been put to the test. So now JeanMarie Han and his colleagues are working on updates and reflecting a lot on this evening's questions. JeanMarie Han was also the head of project that produced the ICRC study on customary international humanitarian law, a groundbreaking ICRC project that assembles for the first time the existing customary rules in international humanitarian law and serves scholars and practitioners as the primary reference tool. As legal advisor with an impressive career, JeanMarie Han has led and contributed to many more ICRC and other projects. And third, and definitely not least, Colonel Jelena. Colonel Jelena is Director of the Irish Defence Forces Legal Service. Colonel Lane has a distinguished career as military lawyer, both serving as legal advisor and prosecutor for the Irish Armed Forces. Colonel Lane has also numerous deployments abroad and a vast experience in peace operations. Colonel Jelena regularly teaches international humanitarian law, military law, and military ethics in Ireland, as well as international courses organized by the ICRC, the Sanremo International Institute for Humanitarian Law, and GCSP. Professor, Mr. Hankerts, Colonel, thank you very much for being here tonight. So let's go to the debate. I'll ask a couple of questions to our distinguished panelists, but then it's really about you, our distinguished guests. So I invite you to then take over the discussions and guide them with your questions and comments. So let's get started. Professor Evangelista, 7 years after the adoption of the Geneva Conventions, what is the general state of affairs? Are the Geneva Conventions effective for guiding behavior in war? Why do states comply with them? And what are the main factors and mechanisms for compliance?
Well, thanks very much. Thank you for the invitation to participate in this panel, and thank you for the kind introduction and for not mentioning the two features of my biography that might disqualify me from the panel, namely that, unlike the other panelists, I have no formal legal training and no military experience. I am trained as a political scientist and historian, like my co-editor of the book, Nina Tannen, and our interest in the topic was to explore what social science theories could contribute to understanding the effects of the Geneva Conventions, not only compliance, strictly speaking, but the overall impact of the regime on behavior of states and non-state actors in armed conflict. We were inspired to a considerable degree by the customary law study and the methodology of that study. We assembled a team of experts, which did include lawyers and military veterans, as well as historians and social scientists, to produce detailed case studies of particular countries and armed groups. And so my contribution today will be, and my answer to this first question will be in the form of summarizing some of our findings. We start, since Tobias asked about mechanisms, we start by describing the main mechanism that social scientists have identified to account for compliance with the laws of war, namely reciprocity. Studies have shown reciprocity to be at the heart of fundamental features of the Geneva Conventions, particularly the treatment of prisoners of war. It clearly serves the interests of both parties to an armed conflict, not to kill surrendering fighters, but to keep them safe and return them at the end of the conflict. Otherwise, everyone would be fighting to the death, and the intensity and cost of war would escalate for both sides. Some have argued that the mechanism of reciprocity is so important that some of the provisions could have emerged in the absence of formal treaties. One thinks of diplomatic immunity, for example, that envoys are not kidnapped and held for ransom every time they travel to a foreign country is not only a function of law, but of custom based on the reciprocal self-interest of the states involved. But in our study, we did not want to look at cases that lent themselves easily to an explanation based on reciprocity. Instead, we chose hard cases where we might not expect reciprocity to play a role. Conflicts that involved insurgencies and counterinsurgencies, terrorism and counterterrorism, where we wouldn't, in our theoretical expectations, anticipate reciprocity, and we would have to look to other explanations. My co-editor was particularly drawn to the literature in sociology and law on socialization and internalization of norms, especially the notion of transnational legal process associated with the US law professor and sometime government official, Harold Hongju Ko. And two of our authors, Amichai Cohen and Eyal Ben-Ari, who did the case study on Israel, provided a useful scheme for evaluating internalization by identifying 3 levels in a hierarchical military organization. It's a kind of commonsensical division, but we found it quite useful. At the top, policy decisions of the Supreme Command and civilian leaders. At the middle level, operational decisions of mid to upper level military commanders. And then tactical decisions of specific soldiers or junior officers. So you can imagine various combinations of compliance and non-compliance at each level that could lead to committing or refraining from war crimes. We borrow an insight from Elizabeth Wood's valuable survey of sexual violence in wartime, where you could have undisciplined troops committing crimes, or you could have highly disciplined troops committing crimes because the top leadership ordered them to do so. And of course, every range in between. So let me just wind up this part by giving you a simple example for one of our hard cases, the Algerian War of Independence against France from 1954 to 1962. As one of our authors, the French historian Raphael Branche, confirms, the widespread use of torture by French paratroopers in Algeria wasn't a product of poor discipline, it was a product of a deliberate policy of torture directed by their superior officers. France had signed the 1949 Geneva Conventions, but did not argue that it applied to this particular conflict. We do find one possible example of internalization of norms in a US case at what we would call the middle operational level. It came in the US treatment of civilians caught up in the conflict in Afghanistan, captured in Pakistan in late 2001 and 2002. The legal requirements of the Geneva Conventions state that if there is doubt about the status of captives, they're military or civilian, they must be brought before a competent tribunal to make an assessment. Until their status is clarified, they must be given the basic protections accorded to prisoners of war. I know many of you have this memorized, but I have it written down. Article 5 of the Third Geneva Convention of 1949 provides that should any doubt arise as to whether persons having committed a belligerent act and having fallen into the hands of the enemy belong to any of the categories enumerated in Article 4, which lays out the criteria for prisoners of war, such persons shall enjoy the protection of the present convention until such time as their status has been determined by a competent tribunal. The point is that U.S. Army officials were prepared to comply with these provisions when the U.S. invaded Afghanistan in 2001 because of their training. And much of what we focus on as source of compliance, even to the point of internationalization, is based on training. So in the wake of the Vietnam War and the war crimes committed by American soldiers at My Lai and elsewhere, the Department of Defense instituted a program of training and education to prevent further violations of the laws of war. A directive originally issued in November 1974 stated that all members of the armed forces must, quote, comply with the law of war during all armed conflicts, however such conflicts are characterized, and with the principles and spirit of the law of war during all other operations. The directive was reissued in 1979 and 1998 and was in effect during the conflict that became known as the Global War on Terror. So regarding the process of evaluating captives to determine their civilian or military status, it was so familiar to US officers that the Army used the shorthand term Article 5 tribunals to refer to it. They had used it in the 1991 Gulf War, for example, to evaluate over 1,100 captives. But in the case of the war in Afghanistan, the top leadership, George Bush, Richard Cheney, Donald Rumsfeld, Condoleezza Rice, said, no, let's not treat the captives according to Geneva law. Let's put diapers on them, hoods on their heads, and send them to Guantanamo or various black sites to be tortured. So here we have an example of military commanders and probably the rank and file soldiers who had internalized the norm, but the political leadership broke it. So as Ben Ari and Cohen suggest, compliance or non-compliance at this level is not an issue of knowledge, but of politics. So I'll stop there.
Thank you very much, Professor. Very interesting. So you're saying that one of the mechanisms generally said is reciprocity, another one is internalization. In the case of Afghanistan, training had proved effective at one case, examined case, of course, and in others, however, it was not an issue of knowledge, but of politics. So thank you very much. JeanMarie Han. Now, The ICRC is indeed in a privileged position to assess compliance with IHL. In addition to evaluating compliance in modern conflicts, could you provide an example or another example of an area where the Geneva Conventions actually proved effective?
Yes, thank you, Tobias, and thanks for inviting me. I'm the late stand-in, as you've heard, and I realize now that I'm responsible for making this also a manual, for which I apologize. But here we are. And I also wanted to first answer the question that's on the screen. Do the Geneva Conventions matter? By saying, of course, yes, I think they do matter, because otherwise we wouldn't be, here today, and otherwise we would also not be updating the commentaries on the Geneva Conventions. I think to answer your question about their effectiveness and examples, I'm pretty sure that we would be worse without them. We would, of course, where do we come from? It's a total war during the Second World War, with few limitations. Much less limitations, and we saw the kinds of bombing that took place in cities, the kind of area bombings, aerial bombardments, and carpet bombing, the disregard for civilian populations in occupied territory and for detainees. So from that to today, so even if we're looking at horrible situations like we've seen in Syria, I think if we keep that in mind. I'm not saying that this is all in compliance and there's nothing bad, but still we see that the framework to look at and the lens that we look at these events today has changed, and that's because of the Geneva Conventions and the developments around them. Whether that's the law itself, the words in the book, or whether there are other compliance factors, pull and push factors, of course, I'm not a social scientist to analyze this, but here, I would also just add that international law is, to some extent, it's law, so it's similar to domestic law. I mean, we also today did not kill someone, I hope, and we didn't steal, and we didn't commit a number of violations. And why did we not do those? Is it because of the Swiss penal code, or is it because we've internalized these rules, or is it because, yes, we all agree that there need to be certain limits and rules in place to our behavior? So, of course, these rules that are in the Geneva Conventions are absolutely necessary to preserve a minimum of humanity in these situations of armed conflicts, and so that's what I would like to underline. It's from the experience of the Second World War and before, this saying no to total war and bringing in a minimum of humanity, even though there are also regularly violations of this law. But as I said, we would be worse without the conventions and without the framework at which we now look at all the conflicts. So examples of where the Geneva Conventions have proved effective, of course there are many, because each of the conventions has had effect and has proven effective and practical. Mind you, also in 1949, most of the delegates at the International Conference were military. So they were quite aware of the military, realities, and they adopted and agreed rules that were in accordance with military practice and what they could, what they thought was feasible in circumstances of armed conflict. And it was not so easy as we think, because I learned this from reading one chapter in the book about the origin of the Geneva Conventions. It was not like, there was no convention on civilians, so they adopted the Fourth Geneva Convention and it was all easy. No, it was not. There was a huge debate about the Fourth Geneva Convention. There were no specific rules on non-international armed conflicts, and Common Article 3 was adopted because we had the experience of the Greek Civil War and the Spanish Civil War. That's usually the story you hear. But it was not so easy. It took a lot of diplomatic arguing, fighting. There were forces against the Fourth Geneva Convention. There were forces against Common Article 3. So the states that championed those articles and that new convention had to actually, lobby very hard, and it was certain dynamics that are explained in the book that made this result come through. And later on, it's the same for the additional protocols. They were not so easy to adopt. And as you may know, the additional protocols 1 and 2 were adopted after 4 years of negotiations. There were 4 sessions from 1974 to 1977, whereas the conventions, 4 conventions were adopted in 1 session. So in 49, with less states present, it was easy to adopt 4 conventions. By 1974, a lot of states, new states had come into existence, and so the club of states negotiating these protocols was much bigger, and it was harder to reach agreement. So all of the conventions and all of the protocols have had effect, you know, on wounded and sick, shipwrecked, prisoners of war, civilians, international, non-international conflict, the conduct of hostility. So one could pick any topic, you know, the prohibition of starvation and point to an example. One could pick, you know, access, humanitarian access, and one could give examples, of course. Every day, prisoners receive essential food, goods, are cared for, receive medical care. So all of these examples, there are thousands and thousands of examples that one could point at that show the effectiveness of the Geneva Conventions. And you, of course, never read about them in the newspapers because they're not interesting, they're not news. So what we read about, obviously, is about the failures, the horrible violations that take place, and that we have to, of course, do more and do better to avoid those. So that's obvious. But so to give 2 points of effectiveness more specifically, I would say one important innovation was that the Geneva Conventions ensured that all armed conflicts are covered by humanitarian law. First of all, by introducing Common Article 3, so that also non-international armed conflicts for the first time were covered. And so there's no situation of armed conflict not covered today. And at the same time also making it more objective, based on facts, whether there is an armed conflict and whether the Geneva Conventions apply. This is very subtle and technical, but the Geneva Conventions introduced the concept of armed conflict, whereas before the application of humanitarian law was based on a situation of existence of a state of war, and states had to declare war. So if they didn't declare war, they could deny the existence of and the application of the Geneva Conventions. Today, it's based on an objective assessment: is there an armed conflict? And if there is, then the Geneva Conventions apply. And this applies both for international armed conflicts and non-international armed conflicts. So they filled this critical gap by adding these rules on the non-international armed conflicts, which were later expanded in Additional Protocol 2, and as has been mentioned, most conflicts today are of a non-international armed conflict, so it's obviously quite important. And then another example that I could mention, picking up on the issue of detention, and the Third Geneva Convention, 1949, and you can pick up any article dealing with food, clothing, accommodation, medical care, and of course you can have success stories and examples of compliance for each of those articles. But I'd like to mention, you know, effect beyond situations for which they were specifically written. First of all, that these rules in the Third Geneva Convention dealing with prisoners of war, many of the rules have inspired and have been applied even in non-international armed conflicts. For example, the types of, you know, international, non-international conflicts where states go abroad to fight armed groups in another state at the invitation of a state, like in Afghanistan. And the armed forces, of course, come with the training that you've mentioned, with the rules internalized about how they're supposed to treat detainees. And so they apply this expansive framework of the Third Geneva Convention even to detainees in non-international armed conflicts. And I've seen even a situation where they were applied, you know, beyond armed conflict. Recently went to South Africa and visiting Robben Island, and I was extremely surprised, you know, by the guide who had been imprisoned in Robben Island and his reference to the Geneva Conventions, and the things these political prisoners who were not, you know, recognized as prisoners of war, and the Geneva Convention was not seen to apply, but by analogy, they requested all sorts of benefits based on the Geneva Conventions and obtained many of them. And I can assure you, and you can imagine how important these practical things were that they achieved by reference to the Geneva Conventions. I was very, touched by seeing the lines of the volleyball court in the courtyard where Nelson Mandela had his prison, cell number 3, because, you know, they were imprisoned there for many years. And initially, they were not allowed to play sports. They were allowed very few leisure activities because they had to do hard labor. And so they obtained this volleyball court by reference to the Geneva Conventions. And they also obtained the right to have their own vegetable garden, you know, because the diet was very poor, had no fruit and vegetables, and so a way around that was by letting them grow their own vegetables. So this is an example that also struck me about the Geneva Conventions reflecting these essential or basic standards of humanity that have even had effect beyond situations of armed conflict. So. I'll leave it at that. Thank you.
Thank you very much, Mr. Hankerts, for your thoughts and insights on this. Colonel, so how do you see the practical use of the Geneva Conventions, and what are the practical difficulties? So especially building on your experiences and experience of the Irish Defence Forces, and notably in peace operations deployed in civil conflicts, how do you see, how are Geneva Conventions relevant, and when they come under pressure, and when is that so, and when are they circumvented or even breached? What is your take on that?
Good evening to all. Thanks very much to GCSP and to BAS for having me here. I suppose I should first say that anything I say shouldn't be construed or connected with being an opinion of the Defence Forces or the Minister for Defence. Standard disclaimer. As with Jean-Marie, let me answer the question: do the Geneva Conventions matter for somebody like me and for the obligations and responsibilities that I discharge? Very much so. Perhaps not quite on a daily basis, because I'm in a slightly different position now, but from time to time over the last 15 years, I've had quite a lot of engagement with IHL/LOAC. When you ask the question, what's the practical use of and what are the practical difficulties? It's difficult, I suppose, to place metrics on success or otherwise of the Geneva Conventions. What I'm going to talk about is a number of what might be considered themes or thematic related, and refer to a number of issues as I go along. So when you talk about the Geneva Conventions at 70, you're probably better off talking about the Geneva Conventions at 155, because it's a movement. It's a powerful idea, but it really dates back to 1864. The Geneva Conventions in their most recent iteration of 1949, and it is appropriate to celebrate. But let's go back further than that, and let's talk about the foundation for them and why they exist, but also to capture that notion of it being a powerful idea. And it is difficult. If you think of the suggestion that there might be a war on terror. If terror walked into the room, you wouldn't know it was here. Terror is an idea. So it is in the counter-thesis with the notion of IHL, when we talk about protection, respect, humane treatment. These are ideas that states want to buy into, that civil society wants to buy into, and that the military armed forces that are representative themselves of their nation, their culture, their sovereignty, they want to buy into. So it's very much part of there's a practical basis, there's a practical application to all of that. And with that comes reverse stigmatization. IHL is a club you want to be in. LOAC is what you want your people to practice. You want your troops on television being seen, acting in accordance with the law. IHL has a consistency on a practical basis. Aurel Sari, who's currently based in the University of Essex, is talking about this concept of legal resilience. And IHL and that body of law, IHL, so I am stretching it beyond the Geneva Conventions, has that legal resilience. It's built into it, in particularly since the 1949 conventions. I'm thinking in terms of Article 47, the first convention, in terms of dissemination. I'm thinking in terms of Article 36, subsequently the additional protocols, in terms of the evaluation of new weapons systems, new weapons platforms. So there's a capture, there's an enduring quality, and there's a consistency. That feeds directly into the practicality, and it is an absolute prime benefit in terms of practicality. Familiarity. Soldiers who I teach at all ranks, they refer to the Geneva Conventions. Now, they don't really realise that the body of law that they call the Geneva Conventions is actually far beyond that and encompasses both the Geneva and Hague streams. But that's again related to the fact that it's in the military lingua franca, as it were, and that's another practical benefit of it. So while it appears thematic, you don't realise the currency that gives from the private soldier up to the 3-star general. or air or maritime equivalent. With that vernacular, with that lingua franca, comes a number of practical emphasis. The notion of rules. There are rules that you abide by. They mightn't necessarily know what the rules are, but they know there are rules there. And you may be asked questions about, well, lawyer, where are these rules? What are these rules? What must I do? That then feeds into this notion of routine. Okay? What might in the additional protocols be referred to as, for example, precautions in attack. Routinely will be asked questions before a military operation is planned. Okay? Now this will particularly be in the multinational sense, because that is where Ireland, and that is where my own personal experience comes, in the conduct and planning of military operations. There is recourse to the law. There is recourse to the legal advisor. A US colleague of mine says that, and you can take it or leave it as it is, he says, the military lawyer can say to the commander things that no other advisor on the staff can. So this feeds into the conduct of operations, but it feeds into the routine. This is a routine application, and it is all driven by the conventions, the additional protocols, and that corpus of law that is ingrained in us. Reciprocity. Colin Powell, when he was Chief of Defence of the US Armed Forces, he spoke about reciprocity. You know, we want to be treated as we treat you. Now, reciprocity is a strong, powerful, and practical application. A currency not really to be ignored. In terms of practical difficulties, there are always going to be difficulties. What year are we in? What decade are we in? There was a time when it was very much detainees, particularly in the non-international armed conflict sense. What's the focus on now? And it depends on the particular conflicts we're looking at. Engagement with the non-state actor, bringing the non-state actor into the room, which of course is far beyond maybe what the conventions envisage when you don't talk about Common Article 3. But there's room for everyone in the room at a practical level in terms of the Geneva Conventions. And that is a difficulty, but it's surmounted by, again, that legal resilience. I suppose for me, certainly there's parts of the world where there isn't a high level of awareness of IHL and LOAC. I find that in recent years, particularly in the last 2 decades, the human rights argument, particularly the jurisprudence of the European Court of Human Rights, is in danger of being portrayed as a negative, in that there's a suggestion that it impedes the conduct of military operations. There's a very interesting study, which is a misquote of Clausewitz, talks about the fog of law and the ambiguity that perhaps the jurisprudence of various human rights cases have brought. Don't divorce human rights and its practice from the practice of IHL and LOAC on the ground. I'm not flagging this as a practical difficulty. For me, it's simply something that must be factored into the planning and conduct of operations. But for many, it is seen as a practical difficulty, but certainly not for myself. I think what I will finish on here is a practical difficulty I would see from time to time is that notion of interoperability. And certainly in peace operations, which are, by their nature, a coalition, an amalgam of forces who are willing to coalesce and to engage in a particular military operation for a practical and beneficial, globally beneficial purpose, one would hope. Remember what Napoleon said about coalitions. God, if I have to fight, let it be against a coalition. On the interoperability side, coalitions have different languages, cultures. They bring different ways of doing things. And so it is also in the area of IHL and LOAC. The challenge for people like myself from that difficulty is training, which is something that's going to come up, I think, in a later question. Training, interoperability. But interoperability is not just about speaking one language or having one single type of fuel. It's about legal interoperability as well.
So thank you very much, Colonel. So building also on your experience, so how can the Geneva Conventions be even better integrated into operations and used for the needs of the military? And you mentioned training. If we look at measures other than training, based on your experience as military lawyer, can you give concrete examples of other measures that strengthen IHL's respect by the armed forces?
So for the last, I suppose, the last 10 years in particular, I've developed an interest in ethics, and in this context, and for this forum, military ethics and ethical decision making in particular. So we focus on the notion of commanders, and my interest was, I think, initially sparked by a master's paper, a short essay that I wrote, which was about Article 28 of the Rome Statute, command responsibility or commander's responsibility. And the title of the paper was You Must, You Should, the doctrine of command responsibility. You must adhere to the law. You should sign up to and abide by an ethical code and ethical conduct. So for me, and what I'm trying to do here is, and I hope I succeed, is to illustrate a metaphor, that fusion that exists for me between IHL and ethics. Commanders are not necessarily generals, admirals, and commodores. Commanders can be patrol commanders, checkpoint commanders, vehicle checkpoint commanders. These can be at the lowest level in the tactical rank, but can be very much influential, and can certainly be influential in the negative sense if they do not know their job, if they do not know how to conduct themselves within the legal paradigm that the Geneva Conventions brings us in terms of the conduct of operations. But back to the core three for me, and which is what I emphasize in training, to all ranks, we deal with people with respect, we protect, and we certainly treat humanely. So when you adopt that triad, as it were, okay, at all ranks, you're trying to imbue a sense of nobility, perhaps, or is that naive? But certainly that standard of conduct that is expected of all. So it's a baseline standard, but it is driven by an integration into training of the fusion of IHL, Geneva Conventions obviously, and ethics. In terms of training is not just about spoon feeding, young recruits, people on career courses. It's about making sure that you conduct tabletop exercises, situational training, that you engage with governmental organizations and NGOs, and you bring gender advisors, human rights advisors into high level and medium level training exercises. So you are injecting into the management cycle this engagement. Now, while you might think I'm going beyond the Geneva Conventions here, remember, I'm not straying too far from my three: respect, protect, and humane treatment pillars. Because you capture your advisors, you capture the people out there, the agents of civil society, as it were, that the military and people like me must deal with, and you inject that into the military decision-making cycle. So as well as bringing in ethical decision-making, conduct of operations ethically, you're bringing a wider stage. You are not hiding behind the garrison walls, as it were, in terms of your mentality. And the commander is important there. Article 47 of GC1 talks about disseminate. Disseminate, for me, goes far beyond publishing. Publishing pamphlets, publishing leaflets, publishing books. Disseminate means informing, promulgating, far beyond publishing, far beyond training, getting into the syllabuses of training, getting into the texts, getting into that mindset, which contributes further, I think, to the notion of the idea and the consistency and the familiarity that the Geneva Conventions have given, which is a plus and needs to be continually harnessed. On the challenging side, and in training, I find things like cyber and what is certainly going to be and it's been recognized as a challenge, the evolution of artificial intelligence. On the weaponry side, I speak in terms of the military. I know there's a lot of good work being done about this. When I speak about artificial intelligence, I'm not including drones in that category. I'm talking about the weapon system that, when it is deployed in the battle space, it has the ability to find, fix, strike, and find again, recommence the cycle without human engagement. That is something that I would flag as a concern. But what does IHL do about that kind of issue? It goes back, it reharnesses, it relies on its legal resilience. I put issues like that into the training exercises as a challenge. And we're fortunate that we have the benefit of international engagement. We have to keep sending our military commanders on courses, whether it's GCSP, whether it's San Remo, wherever these courses are being done in the multinational environment. That brings a standard of interoperability, brings a standard of awareness, and it brings a challenging environment for the commanders of the conflicts of tomorrow.
Thank you very much for your thoughts and reflections. So, Mr. JeanMarie Henkerts, if we go a little bit above and beyond the current or the narrow question, how do you think, which are the current and future challenges of international humanitarian law in general? And Colonel Lane has referred a little bit to it already. But on the other hand, also 70 years after 1949, with some transformations, some called even disruptions in warfare, in international politics, do you see a need for new Geneva Conventions, or how do you think about that?
Yes, thank you. Well, I'd like to start with what Colonel Lane has said. We're not celebrating 70 years of the Geneva Conventions, but 155 years of this powerful idea, and the Geneva Conventions have been updated several times. So in 1907, 1929, 1949, and then we've had also the additional protocol. So there has been an update, and the law keeps on developing, but it's true, it's more difficult each time, it seems. As I mentioned, in 1949 there were about 50 to 60 states, so the club of states negotiating the treaties was small. They took several months to come up with 4 conventions, and then 1974 to 77 the club of countries was much larger with the decolonization and other events, and so it was harder to adopt the protocols. And since then we've not had a global overhaul of the Geneva Conventions. We've not had an update, not a new, a new edition of the Geneva Conventions, so to speak. And we've had developments in sectoral areas, and in particular in relation to the recruitment of children, for example, or in the area of weapons, various developments. And some of those developments in the area of weapons have not been adopted by consensus, but by a group of like-minded states, banning cluster munitions, or most recently nuclear weapons. So a group of like-minded states, going forward and adopting a very progressive treaty, if you like, and then hoping that others will follow gradually. The ICRC examined a few years ago, scanned the whole area of international humanitarian law, and seeing where there are gaps and where developments could take place or should take place. And we had identified, out of 20 to 30 topics, 4 areas where we thought there were the most gaps, because of course any rule can be updated and improved. Even the rules protecting the wounded and sick, which go back to the very origin of IHL 1864. Every legal regime needs to be updated. Again, think about domestic law. It's constantly updated, amended to keep pace with developments. So this is also true for IHL, but unfortunately in international law, lawmaking is a bit harder and it goes slower. So we had identified 4 areas, one being compliance, the other detention, the other being the environment, and the 4th being the protection of internally displaced persons. And of those 4, 2 were then selected as being, most in need of development, and those were compliance and detention. And after 8 years of discussions with states, we came to realize last year that states at this juncture are not able to agree on new rules, or able and willing to discuss these areas, and also maybe willing to discuss best practices and adopt non-binding soft law instruments, as they have done for the regulation of private military and security companies, where there is the Montreux document you may have heard of, which is a non-binding instrument. But there is no appetite and no possibility right now to get agreement for a new binding treaty, let alone, a new overhaul of the Geneva Conventions as such. So I think it's important. We have the Geneva Conventions. They've been universally ratified, so that is an important achievement, or with the French word, an acquis, that we need to, of course, keep and maintain. Common Article 3 is an extremely important achievement, acquis, that we need to preserve for non-international armed conflicts. And we can maybe in the future develop additional rules in sectoral areas. So on compliance, one of the ideas was that there is no meeting of states parties to the Geneva Conventions, unlike most of the other treaties in this area, like the Chemical Weapons Convention, the CCW, Convention on Certain Conventional Weapons, the Hague Convention on Cultural Property. They have committees, they have meetings of states parties, and these meetings are extremely important for states to meet, to discuss issues, to flesh out problems, to agree on interpretations, and to also, ensure compliance. And such a mechanism has not been, for the moment, been adopted for the Geneva Conventions. But I think the idea is out there, and I think the world is not ripe for it, but it will eventually come because it makes sense. It's a good idea. The protocols of 74, 77, the drafting of those protocols started in 1926 or something like that, after the First World War and before the Second World War. So it took like 50 or more years to get this idea of rules on the conduct of hostilities codified in the protocols and the definition of military objective and so on. This took decades, and then the Second World War came and the rules weren't adopted, and then after the Second World War, further and further. So sometimes it takes a lot of time to get to this agreement, and so we have to be resilient and patient, and also keep working on it, and I think one day there will be something in this area. The other area I will not speak so much about is detention in non-international armed conflicts, but as I mentioned before, nevertheless the Geneva Conventions have had a positive influence on detention in non-international armed conflicts, and we wanted to very much flesh this out and put this down in rules, but this also hasn't been possible. Other challenges that everyone has on their mind, and they've been mentioned of course, is new technology, and definitely this will pose challenges for the application and interpretation of the Geneva Conventions. Cyber warfare, everyone is discussing and thinking about how could this apply. There's been a manual adopted, the Tannen manual on cyber warfare, how the rules of IHL apply in cyber warfare. Artificial intelligence, how will this work if machines take over decision making? Is this a good idea? Should we ban this? And so on. So discussions are ongoing, and I think this will be a challenge. But as I've been told by my military colleagues, they said, new weapons, new actors, new technology, but same rules. It's important that we go back to 1864, 155 years ago, 1949 Geneva Conventions. We maintain these rules, and these rules are still fit for purpose today. That's what my military colleagues say. So I'm also not a military. And one could think that, they might say, oh no, these rules are outdated now and you need to really make new rules because now there's artificial intelligence, cyber warfare and other technologies, and these rules adopted in 1949, they are not fit for purpose. But they say the opposite. They're more relevant than ever, they're fit for purpose, and we have to, of course, apply them and interpret them in the context of these new weapons. So I've gone a bit, to the challenges that we had identified, and the attempt to develop new law, but underlining that it's difficult today. Nevertheless, I think there will continue to be developments, and at some point, compliance mechanism will also be adopted, at least the meeting of states parties. I think it's a necessity. The world is simply not yet ripe for it, but we need to keep trying, and at some point, I hope it will happen. And then, as I said, for new technology, the rules are still fit for purpose, and it would be anyway difficult to make a new Geneva Convention for new technology, let's say. because it's difficult to develop new rules in this area today. Thank you.
Thank you very much. So it seems that challenges are ahead, as usually, for IHL, but at the same time, the 155 or 70 years old legacy is just getting started. So, if I may ask Professor Evangelista, maybe a small step back, maybe not, but your book finds that compliance with the Geneva Conventions was affected by the progressive shift from conventional warfare to asymmetric conflicts. So in particular, counterinsurgency and counterterrorism operations. So how do you assess that? Did the Geneva Convention survive this threat? And more importantly, will the Geneva Conventions hold in future dynamics of international power competition that we're seeing now arising again?
Thank you. Well, I mean, this topic, I think, follows quite directly from the comments that JeanMarie Han just made. When I first started learning about this topic, I was aided quite a lot by my colleague at Cornell at the time, David Whitman, who's a foremost specialist on IHL, and we organized a conference together that produced a book, I think in 2005, called New Wars, New Laws, with a question mark. And we had a lot of excellent specialists. I learned a tremendous amount. But one thing that really struck me on the topic of, how relevant are the Geneva Conventions, should they be updated and that kind of thing, to take account not only of new technologies but also new conflict situations and so forth. There was a consensus among the lawyers who participated in that conference that of caution about opening up that issue, what you just said about convening to discuss the Geneva Conventions overall. And what sounds like a conservative perspective from the military may be, the rules have served us well, let's not mess with them. I think the source of the caution was the fear that opening up a discussion about many of these principles might lead to fewer protections, especially for civilians, rather than greater ones. And I'm going to talk about that in just a moment. But so overall, I think I'm probably more pessimistic than my co-panelists, and I'm sure more pessimistic than my co-editor of the book, Do the Geneva Conventions Matter? Because I know Nina Tannenwald really expected to find much more evidence of internalization of norms that would serve in these circumstances when the mechanism of reciprocity wasn't present. And our authors didn't seem to find all that much. But before I talk about my pessimistic outlook, I will say something a bit more positive or hopeful, let's say. And it's, so Colonel Lane mentioned General Colin Powell's emphasis on the importance of reciprocity. In a way, given that many of the situations the United States faced after September 2001 did not have this element of reciprocity, it's interesting and in a way hopeful to me that the US military intended to think in terms of their obligations. Because they were told by the political leaders in the Bush administration, in effect, look, your enemies are not going to accord you these rights and protections. I mean, terrorists are in the business of torturing and cutting off the heads of their captives. They're not going to behave in a reciprocal way if you treat them well. And the military almost uniformly would respond, we are obliged to treat our captives well. And it was as if, or was it that they didn't understand the concept of reciprocity? I don't think so. It was that they understood that just because your enemy does not abide by the rules, it doesn't mean you throw out the rules. That actually, if they violate the behavior, if that's widely recognized and stigmatized as wrong, it actually reinforces the norm. And so a more sophisticated understanding, I think, of the value of the norm among the professional military than among some of the political leaders. And for me, that's an encouraging point. Another point that JeanMarie Hankerts mentioned was when you find situations like the South African prison where some of the norms are adhered to, even though there's no formal obligation according to the law to do so. So our author of the chapter on Algeria, I mentioned Raphael Branche, she found that even in a horribly brutal war, there were, where the French did not, said the Geneva Conventions absolutely do not apply, nevertheless there were elements that resemble some of the rules. So in 1957, General Raoul Salan, for example, established camps for fighters in the Maquis, not people who had been accused of exploding bombs and engaging in terrorism, but fighters. He didn't call them prisoners of war camps. He didn't call the people imprisoned there prisoners of war. They had a term, PAM, P-A-M, standing for prise à la main, taken with arms in hand. And they didn't have the full range of protections of the Geneva Conventions, but nevertheless the prisoners were treated better than they might have been under other circumstances. So for me, that's a positive development. The U.S. fighting in Vietnam apparently treated captives, even South Vietnamese guerrilla forces, roughly in accordance with the expectations of prisoners of war. Some people argued it was for practical reasons, so they didn't have to have two different systems for North Korean regulars and North Vietnamese and South Vietnamese guerrilla forces. But apparently the ICRC recognized and commended the U.S. On that behavior. And again, it was before the additional protections of 1977. One other positive element on the topic of dissemination. About a dozen years ago, I interviewed François Bellon, who was representing the ICRC in Moscow for the former Soviet area, and he described to me quite extensive dissemination efforts, including a curriculum at secondary schools for students ages 15 to 17 in humanitarian law with an exam, obligatory courses in international humanitarian law at law schools, and what he described as unique at the time, an annual plan for dissemination that was approved in coordination with the ICRC by the Russian defense minister. So that seemed like a positive development, but now I'm going to turn to what I see as a more pessimistic outlook. I see two different challenges to the Geneva Conventions, especially related to situations of irregular warfare that we expect increasingly to see. One is sometimes referred to as legalization, where military lawyers, especially in the United States, working on behalf of departments or ministries of defense, interpret the law to render legal the practices that the U.S., in this case, forces want to carry out. Janina Dill of Oxford University has written about this in her excellent book, Legitimate Targets. She's someone you should invite for sure. She's really great. So an example would be the legal justifications for strikes by armed drones in countries against which the United States is not engaged in a recognized armed conflict. This is a paradoxical situation because you might argue that drone technology would make it easier to observe in bello restrictions on harming civilians. But the US military and political leaders and their lawyers define civilians worthy of protection much more narrowly than what the ICRC says has become part of customary law, Rule 6 in your excellent book, that civilians are protected against attack unless and for such time as they take a direct part in hostilities. That's a very constraining definition from the standpoint of militaries, and US officials typically declare anyone killed in a drone attack, even if not the original target, to be an enemy killed in action after the fact without any investigation. So that's an example of legalization, stretching the definition, limiting the protections done in very legal, formal language, but it seems like a step backwards for protection of civilians. And of course, on the ad bellum side, the U.S. justification of drone strikes as self-defense is far from adhering to the UN Charter's specification that an armed attack has to have occurred. So that's on countries like the United States and the issue of legalization. But whatever threats we think legalization poses to international humanitarian law, the outright violations we see are even more worrying. The deliberate attacks against civilian targets, including hospitals and humanitarian aid convoys by Bashar al-Assad's forces and Russian forces in Syria, despite that dissemination that we learned about. Saudi Arabia's air attacks against civilians in Yemen, the use of barrel bombs, cluster munitions, and chemical weapons. These are the kinds of developments that should make us wonder if the normative structure is intact or if it's unraveling. And I hope my colleagues can say something to make me feel more optimistic than I feel about those issues.
Thank you very much for a very balanced analysis, and for that, thank you, distinguished gentlemen, for giving your thoughts. And I would like to open up the floor to really give you the word and to lead the continued debate.